Hi guys, how are you? So this session that I'm recording is basically to take us through the sources of international law. I'm quite sure I had class with some of us about this very topic, but for those who could not have understood, or those who weren't in class that day, I want to take us through sources of international law in relation to environmental law. When we're talking about sources of international law, we had a few issues that we looked at, but basically we want to now see what law provides for these laws, that for the sources of international law, and what laws are indeed existing that courts use in determination of environmental disputes or other related cases. You will allow me to share with you the video, the screen, so that we can follow. I have shared all these materials. I believe you people received them through your class representatives, and I believe we shall have a very smooth class, and you'll be following what I'm presenting. Okay, so sources of international law, we basically looked at how the sources of international law generally are connected to the sources of international environmental law. There are the difference being that here we are now zeroing it down to the laws, to the international laws that connect or that are in relation to environment or the environmental laws. We would want to look at Article 38 of the Statute of the ICJ. When you remember, or from your international law classes in third year, you must be remembering that this very article is very pivotal when you're talking about the applicable laws for the ICJ. But it's still much relevant in our class today. And if you must not understand any, at least law in our class, have this on your fingertip. So Article 38 of the Statute of the International Court of Justice is to the effect and one that the court whose function is to decide in accordance with international law shall such disputes as are submitted to it shall apply. And one, we have international conventions, whether general or particular, establishing rules expressly recognized by the contesting parties or contesting states. Now, under A, that is one applicable law. Then under B, we have international custom as evidence of general practice accepted as law, excuse me. Then the general principles of law, that is under C as the other law applicable. Then we have judicial decisions as one, and lastly, we have the teachings, or you can call them the writings, you can call them publications of most highly qualified publicists of the various nations. So the test there may be, I don't know, but for it to pass the test of highly qualified publicists, because you realize you do not have to quote each and every person who writes or who publishes as a highly qualified publicist, and as such you quote him or her as a source of law. So you realize that this article does not specifically state that the following are the sources of laws, but it says that the following shall be applied by court in determination of the disputes. In relation, or if you want to relate this article, you would want to give consideration to our section 14 Section 14 of the Judicature Act, Cap 13, if you remember it, is the effect that the High Court, in determination of its matters, shall apply the relevant following laws. And you realize that it mentions the acts of parliament. It goes ahead to mention the subsidiary laws, the regulations, then the policies, the rules. It then goes down to also list the principles of common law. We have the laws of equity or the principles of equity, and then case law. So as you realize under section 14, it gives kind of a hierarchy, and you would want to infer the same knowledge you have of that section to this. They basically do not state the sources, but they state what are those applicable laws. So we want to look at these laws as we have seen under Article 38, and we determine which one takes priority, or which one is the main source or the major source, and which one falls under the subsidiaries. Now, we have here a list of major and subsidiary sources as we have tried categorizing them. And you realize that treaties, you can call them treaties or conventions or agreements, rank first, or they rank under the major sources. Customs, or what we can refer to as customary law, is also under the major source. We shall find out what all these are when we are dissecting each one of these. Then we also have the general principles in relation to the subject matter. Herein we have the environmental law principles. So we shall see those general principles in relation to this topic, this course unit. And after those have ranked as the main or the major sources, we also now have the other sources of international environmental law. We have various courts that have pronounced themselves or given decisions, for example, about environmental principles. Courts have adjudicated over, international courts and tribunals have adjudicated over international environmental disputes, environmental international disputes, and their decisions, their interpretations of the law are not in vain, and they stand as law applicable. When courts are making that decision, they refer to the decisions of courts, and as such, it stands as the other source of environmental law. We also look at the work, the publications, the writings of eminent publicists, eminent scholars. They also appear as the sources of international environmental law. However, we'll see that they are under subsidiary sources. We want to see what these treaties are, what these customs are, and what actually these general principles are, so that we understand that this topic is as it is. It is not as shallow as you may want to think that it is. But we here stating that sources of international environmental law are, of course, the same as those from which all international law emanates. Realize that the sources we did, as I first said at the beginning of the class, that the sources of international environmental law are not any different from the sources we read or we studied under international law. So there is no difference, because when you're even discussing the sources of international law, I'm sure you cited that very Article 38 that we have just cited. And also the only difference is that here we are coming in deeper in relation to environmental law. Okay, what are these treaties? How do treaties emanate, and how do they come through, and are they binding, are they not? Our line here states that treaties remain the dominant source of international environmental law, and that is clear because we realize that parties have their own understandings parties have their own specifications. Now, what they do is that they bring those understandings into writing. And if those state parties bring their common understanding or shared understanding and put it under writing and then sign it, then that is binding on the states. It is law, and when any dispute arises, they will not run to any other provision but to the provisions of the conventions, the provisions of the treaties, or to the provisions of those signed agreements. We're seeing that they facilitate the involvement of non-state actors, such as the NGOs, representatives of salient expert communities in the process. So the non-state actors, we've seen that they can be NGOs, they can be those representatives of certain communities. Yes, lawyers can be non-state actors. Of course, we're talking about highly recognized ones, and they facilitate the formation of treaties. We're seeing that these partners must be considered in light of the fact that in 1990s, treaty regimes had been devoted to most international environmental concerns. Yeah. If in 1990s we had very many environmental issues, then you realize that the most treaties we have in relation to environmental law were signed in those years. Now we're seeing that since then, we have not had a very new treaty. But indeed, what they do is that they are coming up with modifications of those treaties that were signed in then, and a few amendments to adopt the developing circumstances. So very many treaties were developed in those years, in the 1990s, and at the moment we are adopting new treaties. We are getting the amendments or modifications other than coming up with new treaties. We're seeing that treaties provide not only lawmaking processes, but also places where binding legal rules can be found. We had seen that these can be binding because states sign these to be their laws or guiding understandings between them. We're seeing this other terminology of multilateral environmental agreements. And we're seeing that MEAs establish long-term environmental regimes characterized by institutionalization of expert networks and decision-making. Now, I once explained to you that a question, for example, about MEAs should not give you so much headache, because as you see, MEAs are nothing different. They're not different treaties, they're not different laws, but these are various conventions, these are various treaties that are specific to environmental laws. That's why we're calling them multilateral environmental agreements. So if a question comes and it needs you to discuss multilateral environmental agreements, you shouldn't be confused thinking that we didn't study this as a source of law, only that here it's another term yet to mean those agreements, yet to mean those conventions, and yet to mean those treaties. That has been treaties or conventions. We are also looking at customary law being a source or a major source for international environmental law. And we're seeing that whereas it is possible to produce formal treaty norms that are not grounded in shared understandings, one would assume that customary law cannot arise without being widely shared, practiced understandings. That is clear. Even in our domestic understanding here is that for a custom to pass that test, it must have been widely practiced and recognized. The same applies to these international customs. If indeed states are enjoying a certain practice, certain understanding, then even if that same states understanding is not written anywhere in their agreements, if it's not provided for in any law, but courts will recognize that widely practiced and shared understanding as a custom, and it will be applied when resolving such issues. We think that this enriched form of practice is traditionally called opinion juris. Yes, that is another terminology that if a certain practice has been appreciated, has taken over, and has been recognized, then our legal word can be opinion juris. So a question about short notes on opinion juris should not also confuse you, because it is something that will require you to look at the wide practices, at the customs, at the international or shared understandings. Customary lawmaking process is subtle combination of unilateral acts, the practices of legality, corrective action, the requirements that practice must be widespread. Now you realize that this paragraph tells us what we need to get for it to indeed amount to a customary law. You're seeing that it is a combination of unilateral acts, but these acts must be legal in that sense. Practices of legality, they must be collective. A state cannot only recognize a certain custom, and that custom is not being practiced in another state, and you expect it to be recognized as a custom in international law. So it must be a corrective action. Then another last requirement is that that practice must be widespread in order to serve as a foundation for that custom. So the stock of customary international environmental norms remains largely unchanged over many decades, revolving around the duty to prevent transboundary harm and states related to procedural obligations. So if a custom is developed, you realize that it means that it has been enjoyed for a very long time. But in relation to environmental law, it is basically to prevent transboundary harm and state-related procedural obligations. So if Uganda and Rwanda are observing a certain environmental custom, then that means that each state is preventing itself from causing environmental and transboundary harm. And as such, you realize here we have noted that that preventive rule, it appears to be the one we refer to as the no harm rule. So we're saying that the no harm rule itself evolved to include an obligation to protect not only the environment of other states, but also of areas beyond national control. So we're seeing that the idea that international problems are the common concern of humankind, and that all states have common but differentiated responsibilities. So common but differentiated responsibilities, we shall find it in our next topic, which are the general principles of environmental law. But this brings us to understand more what international customary law is. That indeed states come up with that common responsibility. So if states are recognizing something and they are contributing to it with that mutual responsibility, then it means that it has been recognized over time and as a custom, and states have to exercise. Maybe we have looked at the preventive rule, and as such here, the precautionary principle develops with the notion of sustainable development and intergenerational equity. We're seeing that in any case, the no harm rule and the associated procedure duties to notify or warn, inform and consult, and cooperate with potentially affected states that have proven extremely resilient. Okay. So I think that as states are enjoying their custom here, they uphold certain rules. They uphold the rules of prevention. They don't have to cause harm. There is precaution, and there is a common and enjoyed responsibility among the states. We are seeing that due diligence duty also has played a role in relation to impacts on common areas and potential future impacts. So when we look at customary environmental law and all its related elements, we're seeing that the difference is that while treaty law plays a dominant role in dealing with international environmental problems, now custom has remained relevant. Yes, we shall have the treaty has its own provisions in black and white, but there is custom that has remained relevant. There are those practices that have not been put under writing, but have been enjoyed over time by the states. We're seeing especially the harm prevention rule, what we are referring to as the no harm rule, and its associated principles continue to be invoked and developed by international actors. So as treaty law, the primary remains the primary actors in this context, continue to be states and perhaps intergovernmental organizations, seeing that customary law process is also more porous than it may first appear. And seeing that the practices of non-state actors do matter, at least in influencing or constraining the salient practices of states. We looked at who the non-state actors are, and I remember us listing the NGOs. Yes, as one of them, we listed agencies, related organizations, and we are seeing that they play that very and influential role in making the practices of the state salient. Another source or another element that was mentioned under Article 38, under C, we are seeing that we have general principles. We have principles that are specific to environmental law, and we shall be looking through them still in our next chapter topic. We are here noting that although the drafters of Article 38 attempted to strike a compromise, we are seeing that disagreements have remained on what counts as a general principle in the first place. We are seeing that some commentators ground general principles in natural law. Others consider the term to refer to principles of domestic law that are found in all major legal systems, such that they can be considered to be general principles at international law. Yet others maintain that evidence is needed that a principle has indeed found support directly in international law, such that it has become part of the customary international law. So again, we have here very key points to note. We are seeing that we do not have a clear written aspect that says that these general principles must be applied when dealing with such disputes. But we have seen that also disagreements have, from certain commentators, have put these general principles to be principles of natural law. If I want to remind you what natural law is, then you realize that I'll take you to, was it jurisprudence? And we see that these are the laws that, these are the general principles, these are the natural principles that are not written, but maybe the conscience of the people, the understanding of the people makes them understand, makes them realize what has to be done, and as such principles are not written anywhere, but written at the hearts or in the hearts of the people. So that is what some commentators state, that these are natural law principles that must be observed by people when coming up with international laws. But also we're seeing that other commentators consider that these general principles are actually the principles of domestic law. If we come down to Uganda and our related environmental laws, and we see our general principles are, for example, we have PPP, if you pollute, you pay. Another principle is precautionary. Before you carry out an activity, make sure it is the last resort, but you must take all the necessary precautions or prevention. If we have those principles under our domestic laws, then commentators say that actually those are the domestic principles that have come to be considered under international law. But others state that for that principle to come out and be considered under international law, then it must have been proved, it must have gotten some evidence that elevates it to that status that indeed it's now recognized under international customary law. So that is the connection. But this principle, at least, you won't come there and develop a principle and you expect that the principle will from there and then be recognized and appreciated by courts. So those are the different theories under the general principles, but we are seeing that the ICJ, for its part, it has treaded carefully around the general principles. It's preferring to find evidence of state consent rather than draw them directly from an assessment of the legal systems at home. So again, we have seen that you do not just come and accept these principles outright. The ICJ has treaded carefully with this, and in most cases, it requires the consent of the state parties. The perhaps most passionate and detailed defense of general principles in international law, we are seeing that it was recently mounted by Judge Cancado Trinidad in his lengthy separate opinion in the pulp mills case. And in his informed opinion, he stated that the general principles of international law include the principles of prevention and the precautionary principles, as well as the principles of intergenerational equity and sustainable development. That is what he basically stated. He gave that list, and to him, he thinks that this is all that should be gotten for under the general principles. We are seeing that for Justice Cancado, these principles constitute independent, that's looking at formal sources of international law, and refers to Article 38(1)(c) of the ICJ, emanating from the universal juridical conscience. That is for Justice Cancado Trinidad, who gives his list as that. What he stated in his list, surely I do not disagree. And again, as we shall be looking at in our next topic, you'll realize that we shall have to come across these principles that he stated in his judgment. So some leading commentators consider general principles to be a more plausible source than custom. For norms like the harm prevention rule, suggesting the ICJ applied as much by referring to the rule broadly as part of the corpus of international law. So that's a debate for the commentators, considering that actually general principles are more porous or are more plausible than the customs. So thinking that customs could be far-fetched, but principles are clear and they ought to be applied other than the customs. We have the judicial decisions and then scholarships. We have judicial decisions of the courts and international tribunals. You realize that, for example, if the treaty or the convention has a certain provision and black and white, then the courts will be pleased to apply that. If that provision is silent, but customary law has its own principles in relation to what is before court, then court will be pleased to also apply the customs. But indeed, if the customs are also silent, you realize that courts will have to traverse through the available and relevant general principles. Now, if we have a lacuna, courts will have to infer to the judicial decisions. So that is how we are getting into judicial decisions, and we have to take note that they are in most cases or they are indeed persuasive in nature. They are persuasive. I'm talking about the judicial decisions and in settling disputes and in pronouncing themselves on the applicable international laws. We're seeing that the tribunals are important participants in international making laws. They may make, these courts may pronounce themselves on some pertinent issues that have been since lacking in the legal system. And whenever courts make such pronouncements, that's how now we get these judicial decisions as a lawmaking process. So I think that international law also suggests that these judicial decisions and advisory opinions are more or less influential depending on the extent to which they resonate with relevant shared understanding. So we have said that they are influential and persuasive. So international for judicial, I think this was for scholarships for these recognized and highly appreciated publicists, those eminent publicists, you indeed must have passed the test of you being referred to as a publicist. And I remember stating that not everyone who writes an article, not everyone who deliberates or gives a submission on a certain principle should fight for that status, that he should be recognized as a highly writing and eminent publicist. But for example, if I state Malcolm Shaw in his International Law and all those editions, court will listen in, and because they know that this is a man who has earned himself over time and he has appreciated what he's doing and what he's submitting on. So these are the examples of the eminent publicists. We are looking at those respected experts, the ones I've been talking about, and we're seeing that in the language of Article 38, we see that they also contribute to the development of international law. They exert influence through individual publications or through reports prepared by scholarly associations, such as the International Law Association. Also reports by the UN bodies, all those come up to make law. They participate quite directly in the development of international environmental law. They take up roles as judges, roles as you advocates. They take up roles as NGO advisors or delegation members in the environmental treaty negotiations. Yes, so this mobility of experts is but one illustration of the permeability of boundaries between state and non-state actors. So that is it for our international environmental law sources. I believe you can quite understand what I have stated. We have just been discussing what we have as international sources via Article 38 of the statute of the ICJ. But to summarize, we have stated that we have under Article 38(1), we have the international treaties or conventions or agreements. 2, we have the international customs, what we call international customary law. We have the general principles relevant, and those 3 are the main sources. And as the other sources, we can note judicial decisions from various courts, international courts and tribunals. And lastly, we noted that we have the highly qualified publicists. And that was our class today. I believe you guys have picked something. Remind yourself on each and every aspect. Make more research. Find out if there are other law-making processes under international law. Find out examples examples of available customs that we have under international law. We have various customs. Find out, define what opinio juris is, define what erga omnes is, so that you indeed get to have the expert in you, so that in a few years to come, we shall be proud to quote you as a highly qualified published. So that is it. I will take my leave. In the next class, if you have any question, I will be so much available. Wish you a very lovely day and all the best. Take care. Have a good evening.